Good afternoon. Hi, it's Tracy B, the divorce solutionist. So today I am going to do part two. Last week I started on clients' rights and responsibilities, where I wanted to give you an idea of some of the things you should look forward to, you're entitled to, you should expect from working with an attorney. Now, I know everybody doesn't work with an attorney, especially a paid attorney, but the rights and responsibilities I'm referring to, in most states, it doesn't matter whether the lawyer is pro bono or free or paid. Um, there are some obligations that all lawyers have to their clients, especially in domestic relations or family law matters, because of the volatility of the issues that come up. So last week I started on part one. I might do some overlap this today because I don't remember. I never remember where I left off. Yeah, it's easy to do, but I just don't do it. Anyway, and I don't know where my glasses are, so I'm going to try to read what I have here. Um, so clients have the right to be provided information as to the attorney who will be primarily. I think I went over that one. That's when you're working with a lawyer who is part of a firm or organization where there are other lawyers, and other lawyers may take over the case or work on the case, or even staff, support staff, paralegals, etc. You have the right to know that. You have the right to have that information provided to you, um, no matter what. Clients have the right to be informed and present at any court proceeding. I think I did that one. Clients have the right to be provided copies of all documents presented to the court by any party in the matter, unless otherwise ordered by the court. And I'm emphasizing certain words in this one because this is important. So many times I'll ask someone in my audience, or someone I'm talking to, someone who I'm giving advice to or whatever, um, if they have copies of discovery, motions, emergencies, petitions, et cetera, and they'll tell me no. And I'm like, why not? And they'll say, because my lawyer didn't give it to me. And I'd say, why didn't you ask? Um, some lawyers give their clients copies of everything. Some lawyers don't do that because it can be burdensome for them to do that. I mean, not to mention just making copies of everything, but the cost sometimes, because sometimes there are motions that are like this thick. And, if the other side provided, served your lawyer or you with that motion, um, you know, it can be quite burdensome for them to copy it and send those to you, especially if it's litigation that's been going on for a while and you're constantly getting stuff like that. But as a litigant, a party, parent, or just someone who, is part of the action, you should always have copies of, especially the documents that are filed in court. Especially the documents that are filed in court. You want to know. You want to know for several reasons. You want to know because those documents are creating a record. And you always want to know, you always want to be abreast of what that record consists of, just in case you decide to appeal. You would like to know, you should know, what your lawyer or the other lawyer submitted to the court on behalf of you or the other side. You should know that. You should definitely be made aware of that. And don't feel anyway, if making a copy is an issue for the lawyer, volunteer to do it. Volunteer to the lawyer to, take it and make a copy yourself. Take it to Staples or Office Depot, if you're in this country, or your job, and make a copy of it and bring it back. But you should definitely have copies of everything: discovery, motions, petitions, orders, definitely orders. Lawyers have to give you a copy of orders because those are issued by the court, and it basically sets forth exactly what the judge tells you to do or not do. So you should definitely have a copy of that. In certain cases, when I used to practice, I would tell my clients, and sometimes even my coaching clients now, certain orders I tell them to keep on their person at all times, especially in custody situations, because they could get really, 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 really antagonistic, and cops and other parties can get involved. You want to have a copy of the order on you, especially when you're doing pickup and drop offs, or when you're spending time with, if you're a non-custodial parent and you're spending time with your child or your kids, you definitely should keep a copy of court orders with you. Orders of protection, you should keep copies of them with you as well. But yeah, you should always ask for copies of documents, okay? And you're entitled to that. Clients have the right to be afforded reasonable access to their attorneys, okay? Reasonable access to their attorneys. That is very important, because if you watched me last week, you will know one of the major complaints I hear from litigants, from parties, is that they cannot get a hold of their lawyer. And there's nothing worse than being in the midst of especially a custody battle. And things happen every single day in custody battles, every single day. And most of it, you need to talk to your lawyer about. I mean, I'm starting to see people come into these Facebook groups asking questions that they should be asking their lawyers. And it makes me cringe. I mean, I get it, because some of them don't have lawyers, but a lot of them have lawyers. They just don't have access to them. And so they come into a group where there's a bunch of lay people who are going through the same thing, asking for legal professional advice. And that's not the way to do it, because you're going to be, they're not lawyers. They're not professionals. And every single case is different. So you have to, that's why when you're signing the retainer agreement, and last week I really stressed about the retainer agreement, you need to know, the moment you are signing that retainer agreement, you need to know how your lawyer intends to communicate with you. You have to know that from the start. You can't wait until you've already paid and they've already gotten involved in your case, and then you find out that they don't answer the calls, or they don't answer text messages or respond to emails. You don't need to know that then. You need to know that from the onset. And I know sometimes you're in a bind and you need to hire someone, because time is of the essence. But the moment you know you're dealing with the particular lawyer, you have to know what their style is when it comes to communication and accessibility. And that is one of the major complaints that people file grievances for. And I'm going to tell you, when you file a grievance with the bar, the committee, whoever the overseeing body is for lawyers in your particular jurisdiction, when you file a grievance or a complaint against the lawyer for not having access to them, that's one of the ones that lawyers can wiggle their way out of. I'm going to be honest with you. That's one of the premises. That's one of the basis for in a complaint, that lawyers can figure out a way to have an explanation that'll, that will suffice, so that they're not reprimanded. And so, why am I telling you that? Because, if you have that lawyer and you file a complaint and they know how to get out of it, then what's the point, right? That's why it's more important to do it as a preventative measure. Let's talk about it from the time we're signing the retainer agreement. I need to know, how do you answer calls, text messages, emails, pop-up visits? How do you respond? Is there a specific day and time you prefer I reach out? Do you respond within 24 hours, 48 hours, 72 hours? Do you not respond at all? Do your paralegal call? Does your secretary call? Does your wife call? You need to know that, though. You should know that. You should know that. You should get the communication style from the attorney from the beginning. Okay, I can't stress that enough. Clients have the right to make the final decision as to whether, when, and how to settle their cases, and as to economic and other positions to be taken with respect to issues in the case. Okay, that's a tough one. That's a tough one, because lawyers are very skilled at making you think you're making the final decision, right? I mean, I'm anyone who's been following me for the past year or so, I'm a straight shooter. I'm not going to mince words. I'm not going to pretty things up. I'm going to tell you how it is. And honestly, I did it. I did it. I would give my clients all the tools that they need to make the decision that I wanted them to make. Because yes, I know this rule. I know this rule. I know that at the end of the day, it is your decision as the client to decide how a case settles and everything. But when I start, telling you, well, you know what, it's going to cost you another $20,000. You really don't have it, blah, blah, blah. That's my way of getting you to make the decision I want you to make. Right. And I can have my own motives, I don't want to take your case to trial because I don't want to, screw up my track record, my winning track record, success track record. I don't want, if the timing is off, I want to plan a vacation that month that they're thinking about planning your trial, whatever the reason is. And sometimes, yeah, honestly, sometimes cases they should not proceed to trial. I was one of those people. I was very candid. Your case shouldn't go to trial because you're going to wind up being $20,000 in the hole and you're going to get the same outcome you're going to get right now. Right. Okay. So, basically that's it. But at the end of the day, we know we have to frame it so that you are given everything you need so that you feel like you're the one making the final decision. But, we know how to shift things or pivot things a certain way to make you think that you are the one making the final decision. And that gets a little tricky too, because what happens, I've seen a lot when I was in private practice, and I see it now, is that when you're in the lawyer's presence, it's easy for them to do that, right? It's easy for you to say, you know what, I agree, you're right. I'm gonna let's settle it, and these are the circumstances, the conditions, and the parameters, and everything is love, right? You leave, you go home, you have time to think, you have time to go in Facebook groups and ask their opinion, or talk to your friends and family, or a support group, or your therapist, or whoever, and you decide, you know what, I don't like that settlement, and I made it clear to this lawyer way back then that I wouldn't take anything but this, and he or she just convinced me to take everything but this. And so I want to go back to my original position, and now I want to call the lawyer and tell them that. And the lawyer says, nope, it's too late. You already made this decision. I already sent it to the other side. And the judge is going to be really firm and stern about the fact that you already agreed, and now you're telling me that you want to withdraw your proposed settlement. Is that a reason to what are you going to do? What are you going to do? You can go on the record and tell the judge everything that, I just said. You could, be stuck with an agreement that you don't like. You could go back to the drawing board and try to renegotiate. You could do all of those things. As the bottom line is, it is your decision. It is your decision. And sometimes even a judge strong arms clients, litigants, parties to settle a case in one way or another. I see it all the time. They do it all the time. But we're talking about lawyers right now. And so, yeah, if that's the case, then that's the case. Because it is, at the end of the day, it is your decision. It is. And you should feel comfortable. You should not let them strong arm you. Yes, lawyers know more. They know the probability, the possibilities, blah, blah, blah. But at the end of the day, and for me, if I think you're leaning toward a certain way, I'm always going to, even as a coach or strategist, I'm always going to make it clear to you what it is you're signing up for, what it means in a practical sense. I'm going to make sure you clearly understand that once life resumes, you're no longer in court, what that settlement is going to look like, what it's going to feel like on a day-to-day basis, whatever it is. I'm going to make sure you're clear about that. Okay. And if you're the kind of client that constantly vacillates, I might get you to sign something, or I might have someone present to make sure they serve as a witness, because I've been screwed a few times with that, and I don't like my clients leaving me feeling like I shafted them. Well, I didn't. I don't practice anymore, but I never liked that feeling. So a lot of times I would try to cover my behind and try to make sure the client felt like, they did have the freedom to choose. Okay. So I'm going to go through a few more because it's 4:17, and unfortunately I have I'm so behind in so much of my work. But so clients' responsibilities. These are I'm on to client. Your responsibility as a client. Client shall provide full and accurate information to their attorney regarding their matter. Right. You have to. I can't tell you how many times clients think it's okay to withhold information. And then guess where I find it out? From the adversary, from the other lawyer, or from the guardian ad litem, or from someone else who shows up to court or to my office with the client. No. And then they'll turn around and blame the lawyer for how things turned out. No, you should be able to trust your lawyer. If you're not confident enough or assured enough to trust your lawyer with all the details, all the facts, all the truths that surround your case, then you should not be working with that lawyer. Your lawyer should make you feel like they can be trusted with whatever the information is. Me, I pride myself, not just in my professional life, but in my personal life. I pride myself on not passing judgment on people. I mean, it's inevitable. We all do. We're human. But I try to make people feel like they can tell me anything. And I make it clear to them from the moment they start working with me. It's important that you tell me everything that you think I need to know. I mean, aside from the fact that I ask a lot of questions, and sometimes the way I ask a question, the way you answer it gives me more information. The way you don't answer it gives me more information than the way you would have answered. So I'm very good at getting information and sort of picking up, sensing when there's more to a story, to a fault. I did that on a post today in a Facebook group about my eyelash is falling off, sorry. About someone came in and made a post about how a judge ruled in her case. And I instantly felt like there was some important details being left out. And I said that. And why did I say that? Because it was a group where it was about, the group was, it was a group that was against family court. And I guess everyone who comes in there shouldn't question what the posters say. They should automatically believe them because they're all anti-family court. And I guess my response seemed like I was pro-family court. And I'm not either way, okay? The point I was making is that I'm so used to asking questions. I'm always looking for the full story. And I have this intuitive ability to know when someone is leaving some things out. It's the way they tell a story. It's the way they start off the story. It's their tone. It's a lot of things. But sometimes it's just a few words, and I instantly know you're leaving out some very important factors there. And so, yeah, they were ready to take my head off in that group, which is okay. You know, if you know me, I don't intimidate easily. But anyway. Yeah, sometimes to a fault, I will sense, oh, I just missed my page. Oh, what did I do? I will sense when somebody's leaving something out. But don't with me. If you plan on working with me, you're going to have to tell me all the facts. And I may come back. I may circle back and ask you a question again and again and again, especially if I sense that you're leaving something out. Because a lot of times when you come back to me later and tell me what happened or what someone said to you or what someone did to you, my spidey senses are automatically going to say, okay, well, what did you say or do to even elicit such a response or such a behavior in the first place? Ah, you didn't tell me that part. Yeah, I need to know that. Okay, before I give you a fully informed opinion or advice, I need to know what you did or said to provoke such a response. Clients shall be available to participate in a timely fashion regarding their matter and to respond reasonably to requests from their counsel. That is one of the main reasons, aside from money, lawyers fire clients. That is one of that. I think that was the number one reason I got rid of clients. And sometimes, I'm going to be honest again, sometimes I use that as a pretext to get rid of a non-paying client, because sometimes, depending on where you are and who you're in front of and what the case is about, it's harder to get out of a case because of non-payment. So what lawyers will do is they'll use another pretext to cloak the fact that it's money. So they may say, my client has been, combative, uncooperative, not participating in their case, and that's sure to get the judge to sign off on a withdrawal of counsel motion. Because the judges say, judges don't like for you to be pro se. They don't. I don't care who tells you otherwise. They don't. They prefer you have an attorney because it moves things along a lot quicker. It's not because of you. They'll say, oh, it's because of your rights. You don't want to, do something, wrong and mess up. No, it's because it moves their calendar along a lot quicker. It makes things happen a lot more smoother and easier if you're both represented by attorneys. Okay. So yes, the judge will sign off on a motion to withdraw if the premise is, or the reason or the basis is that you've been not responding or uncooperative or not participating in your case at your lawyer's request. Okay, I'm going to do one more. I'm going to pass that one. Yeah, this is a good one. Client, you have the responsibility to pay for the legal services rendered on your behalf within the time period set forth in the retainer agreement. So even though that's a responsibility, most of these responsibilities they're there for a reason. They're there so that you know that you can fire your lawyer, but your lawyer can fire you too. Yeah, your lawyer can fire you too. I fired several clients, especially the ones who were really combative or non-cooperative, or who were inaccessible. Because I took it to mean they didn't want to be, they didn't want to work with me anymore. And they just didn't know how to say it. But yeah, you have responsibilities. And if you don't meet your responsibilities, the obligations to the lawyer can fire you too. Right, wrong, or indifferent, it happens. And that's one of the reasons why a lot of attorneys do get out of cases, because, you'll come in there, you'll come up with the initial retainer, and, that's it. A lot of times that's all people have is the initial retainer. They don't have the money to proceed any further than that. And however long or however the case got to the point where, you have a $20,000 bill, you have an obligation to, the moment you can't afford it, to let the lawyer know. I think I've let a bill accumulate to like $15,000 once. I usually don't let bills accumulate that high. Well, it depends. If that $15,000 accumulated within 60 days, that's different. But if you've been owing $15,000 because you haven't paid a bill in 6 months, then that's different. I'm not letting 6 months of unpaid bills go before I ask to withdraw. I'm not going to do that, because if you didn't have the money, 4 months ago, you're not going to have it. It depends. It all depends. But you have an obligation to pay. You have an obligation to be honest with your lawyer about your ability to pay, about your intentions to pay. That sometimes you're expecting a settlement from the divorce, if it's a divorce case, and you can pay them, then. But you have to communicate that. You have to. I don't care if you don't like their services, if they've not been, accessible, if they didn't meet their obligation. You can't keep letting a lawyer do work and you're not satisfied and then expect to get out of paying them. It doesn't work that way. Even if you plan on firing them, the work that they've done up until the moment that you fire them, you're still obligated to pay, unless you go to arbitration or whatever your retainer agreement says, how fee disputes are to be handled. Unless you do that and you win or you prevail, you have an obligation to pay. You can't say, well, I need the money to pay a new lawyer, so therefore I'm not going to pay you for the work that you've done. Not to mention, it's not a good look for you if you go back to the same judge and the lawyer and the judge is made aware of the fact you didn't pay. It's not a good look for you. And it's not something, it's not, I believe in what goes around comes around. I believe in you get what you give. So you think it's okay to not pay anybody, whether it be your lawyer, anybody, for services that they've rendered without disputing it or without bringing it, trying to resolve it. That's not good karma. That's not, especially if you're in a divorce or a custody case and you expect favorable outcomes. That's not good karma. So anyway, that is it for today. I'm going to leave it at that, and I will remember where I left off at. I'm going to leave this up. Oh my God, now my phone is not working. So that I can, there's only a few more left. So I may go through the rest of them next time. But anyway, so you can find me at the divorcesolutionist.com. That's my website. My Facebook page is The Divorce Solutionist. My Instagram is The Divorce Solutionist. My LinkedIn is The Divorce Solutionist. My Facebook groups are The Divorce Glow Up and Pro Se Divorce in Custody. Those are two of my groups where I provide a lot of materials, advice, yada, 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 for my audience in there. I do have coaching packages. I have consulting packages. I do unbundled services for those who don't need a full-on, who are pro se or who are represented, who don't need a full-on representation. I do, I help you prepare documents, review documents, have someone served. I look up, do background searches. I look up cases for you. I screen judges. I screen lawyers. These are all the services I offer at the Divorce Solutionist. What else I do? I am working on a book, my first book, which should be, the first chapter will be released free. You'll be able to download that free if you follow me. It'll be everywhere. And then the full book will probably be released sometime this fall. It will be on strategy. Strategy is my jam. Strategy is what I focus on. Strategy is something that I pride myself on, using strategy in family court so that you could get more wins, better outcomes without breaking the bank, without losing your mind, and without wanting to kill your ex, or your soon-to-be ex. So anyway, I do offer workshops periodically, and I'm working on a group coaching session and a membership program. But I do one-on-one too. I do pro se coaching. I coach people who have attorneys, who don't have attorneys, who are going through mediation. And it doesn't matter where you are, anywhere within the United States, even in Canada. I can help you just navigate. Just, I'm a hybrid. I'm a cross between therapist, lawyer, mediator, best friend, clergy, all of those things. I'm all those in one. So I just bridge the gap. When there's things you don't want to bug your lawyer about, or the therapist doesn't fully understand, that's where I come in at. I bridge the gap. I help you understand what the lawyer just said. I help you get clarity about what you and your therapist discussed that you should be working on. I help you, just, navigate this whole process with ease and, what's economically feasible for you. Sorry, my eyes are burning. So anyway, until next Thursday, I will see you then. Look forward to speaking and working with each and every one of you.